Huawei has faced repeated accusations of intellectual property theft. Huawei says it does not need to steal anyone else's intellectual property, and no court has found that it engaged in malicious theft of intellectual property. Court documents that I obtained through Pacer tell a very different story of Huawei's approach to intellectual property. I should note that for the sake of time, I'm only focusing on a few cases. And on that point of malicious theft, at least according to jury instructions that I have read, maliciousness is only a factor that comes up when deciding to award punitive damages. In 2003, Cisco sued Huawei. According to Cisco's complaint, Huawei had engaged in systematic and wholesale infringement of Cisco's intellectual property in order to develop a cheaper router, which Huawei did by copying Cisco's technology, command line interface, and Cisco's user manuals. Cisco said that the copying was so extensive that an IT manager trained in the use of Cisco routers could use the Huawei products in question without training. Huawei admitted that the products contained Cisco code, but that this was less than 2% of the code. In July of 2004, Cisco and Huawei reached a settlement and ended the litigation. Motorola sued Huawei in 2010. According to the complaint, a Motorola employee emailed Jinglong Hu and Ren Jiafei with specifications for the SC300 base station, which were marked Motorola proprietary. The email contained the words, attached, please find those documents about SC300 CDMA 2001X specification you asked. Mr. Hu acknowledged receipt of this email. In its response, Huawei admits that it received the email containing the specification and the words quoted. Huawei admits that Mr. Hu acknowledged receipt of the email and that the specification was also labeled Motorola proprietary. However, Huawei denied having requested the email nor the specification. They also denied knowing that the specification was proprietary. In April of 2011, Motorola and Huawei announced that they had reached an agreement to settle all pending litigation against each other. In 2017, a Seattle jury awarded T-Mobile $4.8 million after finding that Huawei had misappropriated trade secrets relating to Tappy, a robot T-Mobile had developed to test phones. However, the jury found that this was not willful and malicious. Huawei was found to have breached 3 separate agreements with T-Mobile. The US Department of Justice filed criminal charges over the incident. One of the prosecutors said that their evidence includes numerous emails.
During the time period of the alleged crimes, Huawei announced a bonus program for its employees worldwide, that it would pay cash to employees for stealing confidential information from competitors. And yet, and very tellingly, within days of this offer, Huawei USA sent an email to its employees acknowledging this conduct would be illegal in the United States.
According to the scheduling order, the trial is set for October 2024. A Texas jury found that Huawei had willfully infringed upon patents from Panoptis. The patents Huawei had infringed were software techniques used to receive and display video on smartphones. The jury awarded compensatory damages of $10.6 million and enhanced damages of $2.6 million.
In the past, you faced legal challenges from Cisco, from Motorola, from T-Mobile. What does that say about the culture at the company, and what steps have you taken to address some of the issues that came up as a result of those legal cases?
First of all, I think all these cases have been heard in court. We should respect the court's judgments. We require all of our employees not to do anything wrong in this regard.